I think we'll get started now. Thank you everyone for joining this morning. Um, for those who don't know me, I'm Vincent Chung. I'm a senior associate in the immigration team, and I'm joined by my colleague James Ritchie, who is a associate in the immigration team. So just some housekeeping to begin with for the session. Once you've joined, can you please ensure that your mute button has been selected to limit background noise? Feel free to ask questions in the chat function, and today's webinar will be recorded. So if you have any queries, please do check out our privacy policy on the Burness Paull website. So just to gauge the room, and feel free to put your responses in the chat box, how many people deal with right to work sort of generally on their day-to-day basis? Or if you want, you can also shout out as well. So some people deal with right to work checks daily. And that's good. Well, hopefully you can keep us right if we go a little bit wrong. So just to begin with, in terms of right to work checks, it's not unlawful not to carry out right to work checks. So that's the first thing. But it does remain an offence if you knowingly or have reasonable cause to believe, or you are in fact employing a person who doesn't have permission to work in the UK. So effectively, if any one of these reasons are triggered or they take place, then you're at risk. And so in order to mitigate this risk, you should conduct right to work checks before you employ someone, making sure that that individual does have a right to work, and you're able to check their immigration status that way to make sure that they're not disqualified from working or there's no conditions which are attached which would prevent them from working legally in the UK. So over on the next slide, there is Home Office guidance which sets out what physical documents you can usually accept. And these are normally split into List A documents, List B1 documents, and List B2 documents. So category A, or List A rather, these are documents which are which shows which once you've seen it and you've retained that evidence, that individual has effectively an indefinite right to work in the UK. In other words, you don't need to carry out follow-up right to work checks once you've done it initially and you've seen this evidence. So this will apply to British and Irish citizens, and it will also apply to foreign nationals who have permanent residence or indefinite leave to remain. So I'll pass over to James, who'll talk about the next couple of lists.
Hello. So List B refers to those with time-limited visas. So that could be skilled workers, students, spouses, also those with pre-settled status, which you might know from the sort of Brexit days, and of course the very popular graduate visas. I say this as often when companies engage with us, it's with a view to hiring those with graduate immigration status. Has anyone on the call experienced that? Anyone coming in with a graduate visa? Yeah, kind of we nod there. Alrighty. Yep, and then moving on to the second category, List B, which is slightly more rare, but a little bit more kind of important from a sort of checking point of view. So I just gone over List B1, which is the main kind of time limited visas. List B2 categorizes those with an immigration status that expires within about 6 months. So usually that means it relates to those who have made a valid visa application, but the decision on it is still pending, which requires the employer to use the employer's checking service, which is ECS, to get a positive verification notice, or PVN. There's lots of acronyms today, so I hope you're all taking notes. The main difference between the lists B1 and B2 is how long a statutory excuse may last, which we'll come to explain later on in the presentation. Sorry, one moment. I think my Alexa must have just heard me talking. Apologies for that. Yes, so the statutory excuses, they last usually until a worker's permission expires for list B1, whereas for B2, the statutory excuse will be valid for 6 months only. I'll now pass you back to Vincent.
Thank you. So whether you carry out a manual check where you see physical documents or you carry out electronic checks, I would summarize the process for carrying out the right to work check as to obtain, check and retain. So I'll go over some of these with you. So in terms of the next few slides of obtain, for British and Irish citizens, you can do manual checks on them using original physical documents. So you can use a valid or expired British or Irish passport, for example, or if you were to use the newer IDSP process, where you use an identity service provider to carry out your checks on a British or Irish citizen, you need to have a valid British or Irish passport. And for EU nationals and other foreign nationals, generally speaking, you'll need to carry out the check using a share code. Very rarely will you be able to carry out a manual check on foreign nationals. There are very limited circumstances, but for the most part, I would expect that you will be using a share code. So that's what you would obtain from the migrant. And it is worth noting that for the likeness check, so you don't just look at the document and that's it. You have to have that person physically in front of you or on a live video call so that you can check the photo on the document or the share code profile against the person who's in front of you saying this is who this right to work belongs to. If you don't do that likeness check, then you won't. You could potentially be in breach and you wouldn't establish your statutory excuse. So you do need to make sure that you have checked to make sure that the person in front of you, whether that's in person or on a live video call, they are who they say they are. And so on to the next slide, we do cover some of the acceptable documents that we can use. So as I've said, for British and Irish citizens, passports are acceptable. Original passports, they can be expired if you're using or if you're carrying out the manual check. But if they are, if you're using the online digital process for British and Irish citizens, their documents must be valid in order that the identity service provider can do their checks. So for those who haven't used the IDSP, just quickly, it is a process where you can pay for a third party to carry out checks. So they will have a look at the passport, they'll run their checks through their systems, they'll check against the individual, and then they'll provide you with a report. And the report will have a photo of that person. So it's off the back of that report that the IDSP, the identity service provider, that they give to you, that's what you check against the individual in front of you. And then for foreign nationals, sometimes they will have endorsements or conditions on their passport which signifies that they've got an indefinite leave to remain or they've got no time limit. So that endorsement on their passport is acceptable only if that passport is current. So if their passport, so this is for foreign nationals, if their passport has expired and their ILR or no time limit endorsement is in that expired passport, you cannot accept that as right to work evidence. For other individuals, they might not have, so for example, they might be a British citizen, but they might not have a British passport. So in that case, you can accept alternative evidence. and that would include something like a full UK birth certificate and an official document that's got their national insurance number and their name, issued by a government department or a previous employer. And it is worth noting that a national insurance number by itself is not acceptable evidence of right to work. Anyone can get a national insurance, and also a driving license is never acceptable as right to work. Again, anyone can get a driving license. So if someone presents you a driving license, you might be able to accept it as proof of their identity or proof of their address, but it is never acceptable for right to work purposes because it does not demonstrate their immigration status. And I think we're back to James now.
So we'll now move on to the next stage, which is how to check a document for right to work purposes. So much of this is common sense, such as making sure the document hasn't been tampered with, checking the photo and the date of birth are accurate to the individual. The expiry date should always be checked, but I would say more importantly, make sure that what it says on the document actually reflects what is needed for the role. Are they actually permitted to work? Name changes, these do occur from time to time, usually through marriage. So in these sorts of situations, it's worth checking for the marriage certificate, maybe even a name change declaration. Just making sure that the person that you are hiring is actually the person you are hiring. Don't be afraid to ask questions. There are, of course, discrimination concerns to consider, which we'll touch on later in the presentation. But an employer does need to reasonably satisfy themselves that they have adequately checked the documents properly before hiring someone. Has anyone come into that sort of situation before where they're checking the document and the name doesn't quite match up or anything else? No. All very lucky. Good stuff. Alrighty. Well, the next slide is on biometric residence permits. So, as you can see from the dated pop reference, culture reference, we've been doing this a while. Any suggestions on a more with it reference would be greatly appreciated. Most, if not all, of these BRPs expires on the 31st of December 2024, being replaced by e-visas. But that doesn't necessarily mean that the person no longer has a right to work. For example, the individual might have a visa expiring in August 2025, but their BRP shows an expiry date of December 2024. It's confusing, but it's just to kind of make clear to you all that those BRPs, when you receive one and it says the 31st of December, that is not the be all and end all of the situation. Check the share code. That's the main takeaway. It's also perhaps worth going into e-visas themselves. So the rollout began in March 2024, so quite a while ago now. And most of these residence permits, as I say, ended on the 31st of December. Visa holders can quickly create an account online to view and prove their status, and the employers will need a share code from the employees with an e-visa to carry out the right to work checks before employment kicks off. The e-visa situation doesn't, I believe, change too much, as it hasn't really been acceptable to carry out right to work checks using solely BRP since the 6th of April 2022. So this shouldn't be news to many of you, I don't think. Now I'd like to show you what a share code looks like. I appreciate that the image might be quite small for you. You might not be able to read it, but I hope it does give you an idea of what to look for if you haven't already seen one. You'll see it's a sort of government webpage. It'll list the individual's personal details, their conditions, And it'll also provide details of the check itself. You'll see down at the bottom in a wee box. So it's important that you keep a copy of this when you make the check. And now I believe I'm passing you back over to Vincent.
Yeah, thanks for that, James. Just to add, in terms of the share code check, as James has just said, it is important that you keep a copy of that profile from that share code check. If you only view it from the employee side, for example, you won't establish a statutory excuse at all. And also, apparently, and I'm not sure that I would rely on this anyway, but apparently the Home Office do also keep a record of employers who have accessed the right to work, so they would be able to apparently easily see if you have actually went on to view the right to work. And in any event, the share code profile that James showed you, it does also name your business as well. But it's just worth flagging those things up to you for reference. So just in terms of additional conditions, so where you're hiring someone who's a skilled worker, or you are indeed sponsoring them yourselves, there's normally supplementary employment conditions attached. So a skilled worker normally, when they're sponsored, they can only work for you, their employer, their sponsor. But with supplementary employment conditions, they can also carry out part-time work elsewhere. But in doing that work elsewhere, they have to follow very strict conditions. So they can't just work in any job that they want to. It's got to be a job which is on the immigration salary list. So for some of you who might have gone through the sponsorship process before, this is what we formerly called the shortage occupation list. So if they're going to do a job that's on the immigration salary list for another person, that's fine, that's acceptable. Alternatively, they've got to work in a job in the same profession, in the same professional level that they're currently sponsored for. So, for example, if they are sponsored by us as a solicitor, they could work for another law firm if they're also working as a solicitor. But if for whatever reason they went to another law firm but worked as a cleaner, or wanted to work as a cleaner, for example, that wouldn't be acceptable because it's not the same profession at the same professional level. Alternatively, for a skilled worker, they can work in any other job that's listed on tables 1, 2, or 3 on Appendix Skilled Occupation, and that just sets out all the jobs which can be sponsored. So if they're going to work elsewhere, as long as that job is on that list, that's fine. So just using my last example about a solicitor going to another law firm to work as a cleaner is not on table 1, 2, or 3, and therefore that's why they wouldn't be able to work in that job either. So on the next slide, there's some further conditions attached as well. So if they're going to work elsewhere, as long as they meet one of those 3 criteria that I mentioned in the previous slide, they can work externally for someone else. But that work externally can't be more than 20 hours a week in total. So that's not that's a global figure. So it's not that they can work for 2 different external employers for 20 hours each. It's in total, they can only work 20 hours a week. So they could, for example, work for 5 different employers in addition to their main employer. If they're working for those 5 other employers, they would only be able to sort of work on average 4 hours each for those 5 employers to make up a total of 20 hours a week. Crucially as well, they have to continue working for their main sponsor. So if they've resigned or they've not started working for their main employer yet, they can't benefit from these supplementary employment conditions. So it's something that we get asked quite commonly. Oh, someone's just been terminated. Can they now work for someone else? The answer is no, not until they've been sponsored and not under the supplementary conditions. And lastly, any work that they do externally, so supplementary employment, it's got to be outside of their contracted hours of their sponsored employment. So if they're sponsored to work for you Monday to Friday, 9 to 5, then they can only work, for example, weekends and weeknights for anyone else, and they cannot work any hours that they're contracted to work for you. So those are supplementary employment conditions, and they're normally attached to skilled workers. And James will pass you over to additional conditions attached to students.
Okay, so we're now moving on to the final checking stages of retain. So these may seem like obvious steps, but it's something that the Home Office pick up on quite often. So I'll read out a few of them, but the copies must be clear. The date of the check must be written on the copy with a right to work declaration. You cannot just write the date or certified true copy, which we can perhaps go into the details on that the Q&A at the end, because I do feel as though quite a few companies, this is the part that they miss out on quite a lot. Also, taking copies of passports that aren't necessarily the full page, you're missing quite a bit of it. These are the bits that the Home Office pick up on, and this is where we as companies can fall down on. So retention itself, it doesn't stop at making the copy. So the last step here is always to diarise the visa expiry date, diarise when you'll be following up with the individuals. You'll recall I'd mentioned the sort of differences between B1 and B2 lists at the beginning of the presentation, and it's just essential to know when to follow up with that individuals. Now, often this comes from a bit of legal advice from a law firm as well, but a lot of you might have software that flags these sort of issues up. Can I ask, do any of you use software, visa expiry software? No, no, all righty.
Sorry.
Go ahead.
We do have a system where we'll enter the date of the expiry of the right to work, and it will flag. That's monitored consistently.
Yeah, I'm seeing more and more of it in the last sort of year or two, and I think it's good. Companies that have sponsor licenses for skilled workers, etc. A lot of them have been using these kind of IT softwares that I think kind of work hand in hand with a lot of your sort of general HR duties anyway. So I do think they're quite helpful. So every record that you keep does demonstrate compliance, which you'll be thankful for later down the line should the Home Office come knocking. And to sort of drive the point home, I suppose we've created a nice wee kind of infographic, just to kind of give you the sort of broader picture of it all. There is a prospective employee. You have to obtain the right documents, share code, etc. Check the likeness, check the name, go through all the aspects that we have described today, and make sure, and I do hope I'm not labouring the point too much, that you do retain all of those records. Now I'll pass you back to Vincent now for.
Thank you. Sorry, if I could just pedal back on additional conditions. I've just noticed that one of the slides that were previously in got deleted. So that was in relation to the additional conditions for students. So where you're employing a foreign national who's working on a student visa, they will normally have a condition that's attached to them, which says that they can either work up to 20 hours a week or up to 10 hours a week, or no work permitted. So it's very important that when you're carrying out that right to work check on the share code profile, that you are viewing that and you're taking note of that condition. So for some individuals, they will not be able to work at all. So that's quite self-explanatory. They've got no right to work for you. For others, it's up to 10 hours a week. For others, it's up to 20 hours a week, and that's during term time. And how do you determine what is term time and what is not? So in that scenario, you would need to obtain evidence from the college or university to confirm what their term time dates are. And then you need to keep a copy of that. And that will help you demonstrate when that individual can work full-time hours. So where they're in term time, they can only work those limited hours a week. But outside of that, so for any Christmas holidays, for example, Easter holidays, summer periods, they're counted as vacation periods, and therefore they can work full time during those times. So it is very important that you obtain that evidence. On skilled workers as well, where I mentioned that where you're doing where someone is working under the supplementary employment conditions, so where you're not the original sponsor, I would see if you can get a letter from the original sponsor confirming, for example, what their COS code is, what their contracted hours are, etc., so that you've then got evidence what they're currently sponsored to do. As a backup, I would also perhaps get a migrant to sign an undertaking to tell you that if, for example, they stop being sponsored, or if they're employed elsewhere as well, that you can make sure that you're meeting the conditions in terms of not allowing them to work more than the sort of prescribed hours. So it's all about risk mitigation. So as a minimum, I would always get, so this is for skilled workers that you are employing but not sponsoring, I would as a minimum get their original sponsor to send you a letter confirming all of the information that you need. But as an alternative or as a backup, I would also get the migrant to sign an undertaking as well. For student migrants, you might also want to do that as well. Not so much get an additional letter, because once you've got your term time dates from the university or college, that's all you really need. But it might be that, again, you get the migrant and sign an undertaking to say that if they stop studying or whatnot, or if they're going to be working elsewhere, that they let you know so that you're not letting them work more than 20 hours a week in total. So it is very important in any event where there are these additional conditions attached that you are retaining the additional evidence as well with the right to work documents that you're keeping. So on to discrimination, or how to avoid discrimination. So this sort of works hand in hand with sort of general employment law aspects. So assumptions. So obviously we don't want to make any assumptions at all. So we don't want to make any assumptions based on someone's race, their colour, their nationality, their accent, their names. No assumptions at all. Treat everyone the same. So if you ask for evidence later, so if you ask for right to work evidence later in the recruitment process, you need to make sure that you do that for everyone, not just that, oh, someone in front of you is a candidate in front of you is white, they've got a British accent, they've got a very Western sounding name, therefore you assume they're British, and so you don't ask for right to work evidence at the outset. But for someone who is visibly Asian, they've got an Asian name, they might have a little bit of an accent. You say, well, actually, I want to see your right to work from the outset. That would be grounds for potential discrimination, because you're treating two different people differently, and you're asking for right to work evidence at different stages. So make sure that when you are asking to see right to work evidence, no matter who it is, that you're asking for it at the same time, at the same stage for everyone, to reduce the risks of discrimination. Also, don't necessarily assume that a job can't be sponsored. That's something that we do often advise and recommend to our clients that sponsorship is actually quite a good tool. A lot of people think that there's high barriers to sponsor, and that's not to say that there aren't hoops that you don't need to jump through. You do, but it's probably a lot more easier than what most people think it is. And seek professional advice if you're ever unsure, or you're just a bit oh, can we sort of pick your brains. That's what we're here for. So if you're ever in any doubt, do give us a shout. On to the next slide. It's something that I've been getting asked more and more, and that's about trans employees and their right to work evidence. So sometimes they might be transitioning, their documents might be in their assigned gender at birth and not doesn't sort of necessarily relate in line with how they are presenting through their transition. So there is a very, very delicate balance between right to work and potential employment and discrimination laws and wider protection. So, for example, under the Gender Recognition Act 2004 and Equality Act 2010. So obviously you have to treat these matters very sensitively. And you do need to satisfy yourself reasonably, as James mentioned, with anyone that's looking to be employed by you. But in particular, with trans employees, is there reasonable evidence that you can get to satisfy yourself with any discrepancies? And if so, it's important that you keep this evidence as well. So it might be, for example, they've got some medical note or something that's confirming the transition, and it might be that they've got a name change or something. So those kind of types of evidence would be things that you would want to perhaps seek out and address. But it will be a difficult one. There's no sort of The Home Office guidance is quite slow to recognise topical issues, and it's all about reasonableness. So although the Home Office guidance does not specifically cover off how to treat someone who is trans, it's just very important that you do treat matters sensitively, and you do try and get evidence to reasonably satisfy yourself. And it's also worth thinking, if you don't already have it, implemented, what kind of diversity and inclusion training do you have? Do HR staff or managers, interviewing managers, what kind of training do they need? Do you have the necessary policies in place to address these kind of situations? So it's just all about being alert and mindful to these kind of situations. They probably won't arise on a day-to-day basis, but it is good that you have these kind of you have already considered these items, and you've put these policies and training procedures in place. Again, that can help minimise and reduce the risk of any discrimination claims. So over to James about civil penalties.
All right. Before I start on the civil penalties section, does anyone on the call know how much a civil penalty is? This is the rough costs on civil penalties. The figures have increased back in February 2024, but it still feels relatively new to me. The first offence can be a maximum of £45,000 per employee. Now that is the maximum for a first offence, so it's not necessarily always going to be, that right away. And for repeat offences, it's a maximum of 60k. Now again, that's per employee. Now, there are other sort of penalties that are involved in sort of failing to maintain your compliance duties. I'd go into them as well, because it's not just the sort of the financial costs of failure, but the Home Office, the government in general, also can carry out other penalties, which are perhaps not as bad as 60k per employee, but still pretty damaging. They do have a name and shame list, which can cause a great deal of reputational damage to a company. The closure of a premises, depending on your organization, that could kill your organization. And if an organization did want to one day acquire a sponsor license so they can, hire skilled workers and all the rest of it, there's going to be a higher degree of scrutiny. Once you've sort of been seen to commit one of these offences, it's going to be an uphill battle going forward. So those are the kind of main penalties, and generally speaking, certainly in my experience, it's not just the case that you'll get one. If you are to get a civil penalty, you usually will be put on a sort of name and shame list as well. So, not to scare you all, but it is very important to make sure that these checks are done, and not just to make sure that you've got a sort of fully compliant business, but to make sure that your business isn't going to be sort of harshly punished in the very near future. I will move on to the next slide now. I believe we are moving into the Home Office checks. Sorry, pardon me. So these are the three decisions that come from these sort of Home Office checks. As I mentioned, there's the civil penalty notice, where you will be liable for the fine. There's a warning notice, which is becoming a little bit more common, where they indicate that you have done wrongdoing, but it may not necessarily be a sort of systemic breach, but it'd still be on your company records. And a no action notice, no liability, no fine. That's usually in situations where, say, for example, the company has been identified by the Home Office, and they've chosen specific individuals within the company and asked for, the company records, your right to work checks, all the rest of it. And you've come back and you've shown that you've done the right thing. You've checked, you've obtained, you've retained, you've got it all there. And you have essentially kind of overturned any possible penalties, which is a lot of the work we do involves trying to get this kind of result for a client. So on civil penalty notices, there is a 28-day deadline to pay, and usually you can get a discount on these if you pay a little bit earlier. Depending on the company and sort of how generous the Home Office are, there's usually an okay payment plan, but these are worst case scenarios that, all of our training and certainly our advice and assistance is kind of engaged to avoid these sort of situations. And as we'd mentioned earlier on, the statutory excuse is what we would be using in many situations to avoid these sort of penalties. They might come at a company and say that they've done the wrong thing. Well, we can say, well, yes, that individual, they may not have the status, but we carried out the right check at the right time and we followed all of the Home Office's rules on it. We can, of course, object to these civil penalties by way of judicial review, which is a way of challenging the government's decision in court. It can cost quite a lot and it can take quite a lot of time, but again, depending on the size of the company, it may be worth it to avoid not only these penalties, but the reputational damage, which again is quite important. So we're now going to move into specific scenarios. We'll read out a little brief, and then we'll ask you what you think on it, and no wrong answers, we hope. So I'll pass over to Vincent for the first of 3 scenarios.
Thank you. This is a safe place, so just feel free to shout out answers. It won't go beyond this group. So Xiaomi is coming to the UK from China. She's applied for the role of Scrum Master in the IT sector, and the role is for 45 hours. The salary is subject to negotiations. Are there any right to work considerations? What kind of evidence would we need to see to demonstrate she's got a right to work in the UK? Answers on a postcard. Feel free to shout out or type your response in the chat box if you want.
I think Mel might be typing, but I would probably just want to flag up the fact that quite often a condition of overseas candidates' right to work is that they cannot be a sports person or work within a kind of sporting profession. And I'm assuming a scrum master is something to do with rugby, but I might be wrong. So I would want to flag that up. Obviously, obtaining her right to work share code and checking that. And also something to do with the scrum master not necessarily matching up with the IT sector part of her role.
Melissa said any hours of restrictions on a visa, and Will has said salary conditions for a skilled worker. So these are all very good observations to flag up. So in terms of the sports person condition, yeah, absolutely, that is a condition that is on almost every single visa, regardless of whether it's a skilled worker visa or not. Obviously, the only main visa where that is not a prohibition is for someone who is sponsored as an international sports person. So yes, there is normally where someone has a visa, there is a condition that says that it can't do work as a professional sports person. On the Scrum Master being in the IT sector, it is actually a role. I'm not quite sure what it is. It's some sort of engineering role, IT engineering role, but it is something that is in the IT sector. We've got some fintech clients, and up until I think about the end of last year, I would not, well, I mean, I still don't really know what a Scrum Master does, but we find a code for them within the IT sector, and it actually doesn't have anything related to sports. But it is good that you flagged that up as well. It's something that that should be considered. Does the job role match the sector? And on salary considerations for a skilled worker visa, if this individual was sponsored under the skilled worker, absolutely. Your starting point for the minimum salary threshold is £38,700 gross per annum based on a 37.5-hour week. But one thing I want to flag is that we've all kind of gone down the route of this individual is actually a migrant, but what if this individual was a British citizen? So we would obviously, you've all sort of alluded to it, you want to do right to work checks, but this individual might actually be a British citizen already. So all you needed to see was her British passport, for example. But we don't know, we don't have enough information from this scenario, but it's trying to gear you towards making sure that you're asking the right questions, which you are generally, because you all do right to work checks. You would have asked to see this, but I've deliberately engineered this scenario to sort of see what kind of considerations are flagged up. But absolutely everything that has been mentioned are all valid considerations. But I would just say that you need to just make sure that you carry out right to work. This individual might already be a British citizen, but everything else that we've spoken about that you guys have suggested are all things that, if this individual wasn't a British citizen, absolutely these are all things to consider. So on to the next scenario with James.
All right. So John Smith, born in the UK, he's gone through the full Scottish education system. He's in his first year of university studying HR, and he's applied for a role that's 24 hours part-time in the HR team. Do we have any thoughts? Here we go. What right to work does he have? Yeah, good. Good. So that's basically spot on. John
Maybe,
Smith.
sorry,
Oh.
I'm not sure, but maybe we can just check if he spent some time abroad. So if I recall correctly, if someone, a British citizen lived for more than 6 months abroad, we needed to have a police check. Maybe, I'm not sure, something like
Yeah, I
that.
mean,
But if it is Scottish, I mean British, we just the ID, I think, or maybe
yeah, I mean, that's basically spot on. We need to be making the same considerations irrespective of who they are, what their name is, etc. Don't assume just because his name is John Smith and that he was born in the UK that he's British. This scenario fully encompasses the point of this training. Yes, his name is British sounding, and being in the education system this long, it's very likely that he is either British or has become British, or perhaps he's even Irish, but he might not be. I mean, his name could be Jock Tamson. It doesn't matter. He could be American, Canadian, anything really. So a full right to work check needs to be done, just like anyone else. Because if it transpires, for example, that he has an immigration restricted status, he could be on a student visa, the amount of hours that he is able to work, it could be limited. Vincent mentioned earlier on that the maximum term time hours for a student, 20 hours a week. This role at 25 would exceed this, landing the company proverbially in it. So it's always worth checking. So I'll pass you back over to Vincent for our final of the 3 scenarios.
Thank you. Just quickly on that point on criminal checks. Again, it would probably just depend on the role. So, is a sector-specific role that does require a criminal record check? So, for example, if it was in a care sector role, it might be that it needs it needs a PVG or Disclosure Scotland or something like that. If we're sponsoring someone as a skilled worker, then again, there might be specific roles, or there are specific roles where a criminal record check is. But the rule of thumb is that unless it's a specific requirement as part of the job, then generally speaking, a criminal record check isn't necessary. But unless it's a sector specific thing, or you're sponsoring someone and that job that you're sponsoring them under does require a criminal record check. So last scenario, you'll be glad to hear, Mohammed Khan works for your competitor. The CEO is very keen to hire him. What are the right to work considerations here? So any thoughts that anyone wants to shout out or type in the chat box?
I would say the same checks as usual. It doesn't matter if the CEO want to hire him, and so maybe just if has a sponsorship with the other company, so there is a kind of hour limit for us, but the same right to work checks as anyone else.
Yep. Any other thoughts? So absolutely right. What we're trying to get from this scenario, and what you do in practice, is it's always check their right to work. What right to work do they have? And that determines your next step. So again, Mohammed Khan might already be a British citizen, in which case, if you can see his British citizen passport and do his right to work check that way, that's it. You don't need to do anything else. But if he was sponsored by someone else, for example, could you hire him under the supplementary employment conditions for up to 20 hours a week? Or in fact, do you want to sponsor him full time? So absolutely, the main sort of points that we're trying to draw, and just trying to make sure that you are sort of thinking at the forefront, is that you are always carrying out right to work checks. So just to sum up, the main points of the main takeaway points is that you want to carry out, or you should carry out, right to work checks before employment commences for anyone. and you do that at the same stage. And you check, you obtain, you check, you retain. And if you do this and you're following the Home Office guidance and you're doing it in a compliant manner, that's what establishes your statutory excuse. So in the event that the Home Office come and do an audit, which might be intelligence-led, or it might be because you've got a sponsor license and you're already on their radar and they want to check your record keeping. In the event that illegal working is identified, as long as you carried out the right to work checks correctly from the outset and you've kept compliant documents throughout, you will then be able to establish that statutory excuse and have a defence against paying that civil penalty of up to £60,000, which James mentioned at the start. So those are the sort of key takeaway points. We've got a couple of minutes left. Does anyone have any questions or comments that they want to ask or put
yes,
forward?
I have a couple of questions, if I can. So I took a note. Just general questions about the breaches, because James spoke about the penalties. So what happens if we have a visa student, or in general a visa with a 20 hours limit, and the employee works more than 20 hours? So the penalties are those ones we checked with James, so up to, I don't remember, 40,000 or 60,000. And another question, if because as a HR we deal with expired right to work, so when the employee has the right to work expired, we needed to receive the share code or the application reference number in order to check the current status. If there is an appeal in place, so we are not actually able to check the current right to work, the current status, what we need to do in that situation? We need, I don't know, maybe to receive a formal letter from the employee or the lawyer that says, okay, there is an appeal in place, they can keep working, but or we just need to wait the end or the outcome of the appeal. And another question about the sponsorship. So let's say we are sponsoring a person, and if I recall correctly, they need to work, they have to work in the an average of their contracted hours in 8 weeks. But what happens if they are sick or they are on holidays? They work less hours they supposed to do.
Yeah, we'll try and answer as much as we can. I'm just conscious of times and people might need to go back to meetings. So just in terms of if someone's visa has expired, so you've got an employee that's working for you, you've carried out their right to work checks and their visa is expiring or has now expired, and they've put in a new application, or they're going through an appeals process, and I'm assuming that's an appeals through the immigration courts rather than an appeal, sort of an employment appeal. So in that kind of scenario where someone's visa has expired and you've already conducted that right to work check initially, as long as you then get evidence that they've put in a new application or they've put in an appeal, so for someone who's put in a new visa application, as long as you've got evidence of that before their visa expired, that they put in that application, they put in an in-time application, you need to get a reference number, but I would suggest that you just get a copy of their submitted application form, because that will show you the date of application. And what you basically want to see is that they put in that application on or before their current visa expired. In that scenario, in that situation, you will get an automatic 20-day grace period. And during that grace period, you will then want to use the employer's checking service, which James touched on, and that is what would hopefully generate you a positive verification notice, which will give you a 6-month statutory notice. Say that that application is then refused, and then they put in an appeal at the immigration courts. Again, you would need to do a new employer checking service to establish a further 6-month period. So where someone's not able to demonstrate their right to work using a conventional manner, then the employer checking service is generally what you will use to generate a continued statutory excuse for the time being. But bearing in mind your employer checking service, the positive verification notice is only valid for 6 months at a time. So it's likely that you will need to conduct follow-up employer checking services, especially if someone is going through an appeals process through the immigration tribunal. I think you also mentioned something about student migrants working for you for more than 20 hours a week. In that case, they're breaching their employment conditions, and you are knowingly allowing someone to work more than they're allowed to in breach of their conditions. So in that situation, both the individual is at risk, but you as an employer is also at risk of getting fined, because at that point they would have they're working without the necessary conditions or in excess of the conditions that they're allowed to work. So you would, as an employer, be at risk of a civil penalty if the Home Office do an audit and they find out about this individual.
Okay.
Sorry, I'm not sure if anyone else has any questions, or if there's any follow-up questions that we can't get to. Our contact details are on this slide. We are going to circulate the slides and circulate a copy of the recording over the next couple of days. So if there's any questions that haven't been answered, or any questions that you don't feel comfortable asking on this, feel free to reach out to either James or myself, and we can touch base that way.
Okay, thank you.
Okay. So thank you again for everyone for joining. Hope you find it useful. And as I say, we'll circulate the slides and the recording over the next couple of days. And if you've got any questions or comments, then feel free to reach out.